Good morning, Registrar. Thank you for taking our appearance earlier. In opening for the plaintiff, Registrar, our client is John Farrand. Mr. Farrand was wed to the deceased in 1994 and they were divorced in 2002. Now, there are two children to the deceased, Keith and Catherine. However, these children are not children of the relationship. These are children to a previous relationship as of the deceased, as the registrar would have read in our affidavit earlier. Registrar, the deceased unfortunately died on the 27th of February of this year, and probate was applied for and granted on the 4th of June 2026. And it was at that time that our client received a copy of the exemplification packet from the executors, and it was at that stage that that our client read the will and realised that there was no provision for him, and in fact there was a letter or a statement of wishes at the end which explained why my client wasn't provided for, and that was due to a $250,000 gift, which the deceased states was given to our client during her lifetime. Now, our client doesn't deny that $250,000 was received. However, there are circumstances that are outlined in the position statement, which we want the court to consider, which are also outlined pursuant to the summons and the affidavit. Registrar, the divorce did go through in 2002. However, some years after that, there was a relationship which continued between the two, and ultimately this ongoing relationship resulted in the deceased moving in with my client in his property in Coolangatta. Now, what we would say is at the time that the deceased passed away, our client and the deceased were in what was known as a close personal relationship. Not only that, but they were wholly or partly dependent on each other at the time of death, and also during the term of that revived relationship, if we could call it that. Our client is a former spouse of the deceased, and at the time of the deceased's death, they were in a close relationship, living together in a de facto relationship. So there are four potential heads or categories under Section 57 of the Succession Act in which our client is an eligible person. Now, Registrar, in terms of demonstrated need, it is our client's position that he has considerable health issues. He has financial need, not just for his health, but also for the general upkeep of the property. It is a property which not only he lived in, his house, however, the deceased also lived there up until the point of her hospitalisation and passing away. So we would be seeking, under the two-stage test, adequate provision and an order for provision as a result. We would also say that the notional estate comes into play as well. So Catherine, the daughter and one of the executors, and beneficiary of the residual estate, did come into a lottery windfall, and through this windfall she became a joint owner with the deceased in a commercial property which derives rental income. On top of that, she does have a share portfolio. So we would say that those assets form part of the notional estate, and we would be seeking orders for provision from the deceased estate, which would include the notional estate. So we have made several attempts. Sorry, we've made a few attempts. There has been one offer that was forwarded from our firm on the 18th of June. And in response, we put in an offer, and this wasn't resolved, unfortunately. So with these two offers and not being able to resolve the matter, we find ourselves having to come before the court, and we attend this mediation to try and resolve the matter in good faith, as ordered by the court. And my client is certainly open to any offers, and pursuant to the offer, depending on the offer and our instructions, we are hopeful that we can find some kind of common or middle ground here to try and resolve the matter. If not, then unfortunately we'll need to proceed to further direction and or hearing. That concludes my client's opening submissions. Thank you.